Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about passing down your safety deposit boxes. Before I do that though, I want to remind you, if you have any questions related to estate planning or probate, and you want to talk to us over the phone for free, you can do so by going to estatemeeting.com. Calendar's right there. You just pick a time, a date. On that date and time, we'll give you a call and we will talk to you. Estatemeeting.com. All right. So first of all, if you're watching this on video, you might notice that something is different than my other videos. My hair. We are in the midst of the coronavirus sort of social distancing. This is day 54 for us, for me at least, in Kirkland, and it was really time for a haircut. I didn't want to take the time to style it, so we just buzzed it. We just went for it, and it feels good. Sometimes I think it looks good, sometimes I think it looks terrible. But in any event, it's still the same me, all right? And my hair will be back in wonderful sometime in the future. But I digress. Safety deposit boxes is why we are here. And I have another confession to make, or I have a first confession to make, I guess. This is something that I actually did not know until very recently, and I actually thought it was the opposite. I used to believe that, so there's a belief out there, and I used to believe this as well, that if you put somebody on your safety deposit box as a joint account holder, like if you put them on the thing so they can access the box, I used to believe that that person then, if one of the people died, the other person automatically became the owner of the contents of the box. Okay? I believed it was a joint tenants with rights of survivorship, sort of a relationship. Okay? If you ever see joint tenants with rights of survivorship on any of your accounts, on your real estate, on anything like that, what that means is when one of the people dies, the other person becomes the sole owner. Okay? That's an important concept in estate planning and in property law in general. And I believed that was the relationship with joint holders on a safety deposit box. But I was wrong. And I will say this really quickly before you run out and make any changes. If you are not in Washington State, please at least Google this, talk to an attorney in your state, and make sure that this is the case for you, because it could be different depending on what state you're in. Each state makes their own laws with regard to this. There is a specific Washington State statute about this. And so just be aware of that, okay? But in fact, in Washington State at least, joint account or joint holders or joint tenants, joint sort of leaseholders on a safety deposit box, they do not automatically receive the contents of the box when one person dies. And I found this out by having somebody call me and asking me, telling them this thing like, oh yeah, joint account holders, you get the rest, and then going to myself, thinking to myself, well, wait a minute, I should confirm this, which is what I usually do when I start spouting out. And I went and checked, and I was in fact wrong. The way that joint sort of account holders on a safety deposit box are treated are as sort of like joint lessors, joint tenants of this safety deposit box. And that relationship really just means that both people have access to the box. What it also means is when one of the people dies, the person that died, their contents in that box don't go to the other account holder automatically. They go wherever the person that died tells their stuff to go. Okay? So, the point here is this. Often people will put people on their safety deposit box, the paperwork, and with the idea that when they die, that person will get everything. That's not true. The right way to do it, the safe way to do it, is to, in your will, specifically say, John Smith gets the contents in safety deposit box blankety blank 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 at this bank. Okay, give the contents of the box to the person you want the contents of that box to go to. If you want them to go, you want it to go to your kids equally, you don't have to specifically state it in there. But if you do want those contents to go to someone specific, then you need to spell that out in your will or some other writing. The will is the best way to do it, the safe way to do it. Or those contents will be distributed amongst the person who died, their heirs, or wherever their will directed that their assets go. Okay, so important lesson that I learned that I wanted to share with you because I'm learning new stuff every single day. That's why they call law a practice, because it's never complete. You're always getting better. You're always working at it. All right, that is it. If this sparks some questions, or if you just have some other general questions about estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to estatemeeting.com. That is it for today. I am Christopher Small. I'm the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again tomorrow. See ya.